Hello, everyone. We welcome you today on our class dedicated to IP law. Today we have our teacher, Professor Dän Slоун, who is going to speak about IP vocabulary. I'm giving the floor to him. And hello, Daniel. I'm very glad to see you tonight, which is early morning for you, as I understand.
Yes, thank you, Sophia. That's wonderful. I'm very pleased to be here, and I'm glad we have a good audience today, this evening in the Russia area, and I'm so pleased that the IP issue is up today. So we're going to learn a lot about IP. For those of you who have not been here before, I'm a professor in California, and that's where I'm coming from right now, and I'll go ahead and begin our presentation with the Minty.
Yes.
So I need to share it. Yeah.
Yeah, and so you will be able, while the presentation, you will be able also to vote on the questions that Professor Slоун is going to ask you, and we're very eager to start.
Very good. Yeah, the voting, I will go ahead and ask questions, and as I ask the questions, you will have an opportunity to slowly go through and determine what the answer you think is, and we'll go through them afterward. Okay, so just beginning with U.S. legal writing, session 5 out of 6. We have 6 total sessions, and again, my name is Professor Dr. Dän Slоун, and this one is the IP law, the session, and vocabulary. So many of you, I understand, have experience in IP law, and that's wonderful. And there is a great deal of vocabulary here in this particular session. So some of it might seem new to you. So have your translator ready. And there is the barcode again, if you don't have it. And the link, you can take a picture of it or actually go to it with your cell phone at this time. And I always start off with reminding people of something, and that is, in drafting a contract, you should always bear these following principles in mind. Be conversant with the party's wishes. Use a checklist of clauses that relate to the subject of the contract. Be precise in the choice of words, and use several sample contracts to establish the format of the agreement. Very important things to always remember. So we're going to dive right into the issues here. And the first one is, what is intellectual property law? So IP law, some of you have extensive experience, some may have very little. So it protects the rights of any person or business who creates artistic work. So what is an artistic work? How is that defined? So the way that it's defined in IP law is artistic work includes things such as music, literature, plays, discoveries, inventions, words, phrases, symbols, designs. And intellectual property law aims to encourage new technologies or artistic expression and inventions that all promote economic growth. And I can say, through my experience, that IP law is a very big impediment if it does not exist, or more so if it's not enforced. So enforcement is also something we'll talk about later, is how do we enforce the law? Because that really becomes a big issue. I've lived in various countries around the world, China for many years, and Laos, and all over Asia, and assisted with in the Middle East and other places. But I've assisted with this particular issue of how do we protect people for having these creative art pieces, this artwork, so that they'll be encouraged to create additional work. Because if they lose their property rights to that work, there's less incentive. So which of the following is not protected Okay, which, little spelling error there. Which of the following is not IP law protected?
Yes. Oh, Daniel, I'm sorry that I'm jumping in. We have just realized that we actually see your YouTube studio, but not the presentation. I have the comments. So from the audience, and thank you very much for those who wrote to me, because I have a little bit different view. So yes,
But
and now we see it. Yes, and can you please somehow enlarge it a little bit if it's possible? So okay, yes, perfect. No, the previous one was perfect. Yes, no, shorter. Yeah, now it's good. Thank you. Sorry.
Perfect.
Because
No,
I see a different
perfect.
picture. I apologize for everyone. Yes, so
You see a different picture than they do.
Yes. Thank you so much. Now everything is fine. Thank you. Sorry.
Okay. So this is what I introduced at the very beginning. And again, IP law vocabulary, the barcode or QR code in the Minty link, that statement that I gave, my boilerplate, to be sure that you have are conversant and have all the ideas correct in ideology in mind when you're creating a contract. And then what is intellectual property law? Again, it's these things that are protected, the protected rights of a person or business who creates artistic work. And then we have which of the following is not IP law protected. And again, that's a spelling error there. Following. Looks like we still have a few more that are coming in. Very good.
Yeah, and we can see that there is no common ground. Well, there is quite common ground, but still there are quite a lot of interesting questions.
There is a lot of uncertainty from what I see here, or diversity in ideas, which is great.
Actually, I like it also because it means that the point why we gathered here is exactly to learn it and to explain. So, it's great.
I like to tell my students that if they are taking a class and they already know everything, they're probably taking the wrong class. So most of the time when you take a class, you don't know a whole lot and you need to learn something, even if it's a small amount. Like in this case, we're learning a lot about English as well as IP law. So it's fantastic. Okay, so it looks like we have a majority that have public domain works. So which of the following is not IP law protected? And that is correct. It is the public domain works are not protected. And we're going to talk about that in another slide here, right here. So which is not covered by intellectual property law? Works that are in the public domain. Now, all of this is based on American law. US law is what I started off introducing this session with, and that's where I took it from. We will also have a few things that come from international conventions. So, which is not covered by intellectual property law? Works that are in the public domain are not protected by any intellectual property rights because they are not eligible, or because those rights have expired or been forfeited by the creator, either deliberately or through carelessness. Anyone is free to use public domain materials. Okay, so if it's deemed to be in the public domain, and we'll go more into that now, what that means. So just like the legal system protects people's physical property rights, it aims to protect people's mental labor, which we can call intellectual property, mental labor. There are several different types of intellectual property. So we have copyrights, which everyone is familiar with, patents, trademarks, geographical indicators or indications, right of publicity, trade secrets, right of privacy. So some of those you may be familiar with and others you may not. So IP law aims to protect people's what? Labor. See if you are listening.
Okay. Yes, and again, I would like to remind that we have a little bit of delay for our YouTube. So we're now speaking, but the voting will come a little bit later. That's why sometimes it takes some time for our viewers to vote.
Okay. Yes, it's good to give them a little time, and I know this is being done in English, and I hope everyone can understand my California accent well.
You have very beautiful California accent, very American, so we enjoy it enormously. And actually, I do have one question which already popped up about the term forfeit, because this is unfamiliar term for some of the participants, and they asked if you can explain. Well, we can Google it, of course, but maybe you can.
What is the name of the
forfeit
term?
You in the previous slide you used the term forfeit, so someone can forfeit.
Forfeit. I'm sorry.
Forfeit. Yes.
Yeah, forfeit. Okay. Yeah. In what that means is you either willingly or unwillingly give up. You give up the right. So sometimes that will happen, and I believe I can go back here while people are voting. One more right here.
Yeah, it's over here. Yes, has been.
Okay, so protected intellectual property rights, because they are not eligible, or because those rights expired or been forfeited. Okay, so forfeit means that
to waive, to give up,
to waive.
surrender.
It's just to waive. What happens and let me give you a sports analogy. It's if you have two basketball teams playing and one team only has 4 players and not 5, then they forfeit the game through some default. It could be a default of some form that they say, okay, I give up. I will give up my rights. I will. So
yeah.
in this sense.
And yes, thank you very much. Apologize. And I wanted to ask then, can we, for example, use it for any advance payment? For example, I provide an advance payment for a flat, and if I do something wrong, I don't know, break a TV, then I might forfeit my advance payment, like a deposit or something like this. Can we use it in these situations?
That is a great example, and that happens many times. What will happen is the university, for example, if it's a payment of tuition fees, they will give you a deadline. And if you go past the deadline, you forfeit your tuition fees. So
it's like formal word of losing.
Losing. You either do it intentionally, forfeit, like in the play, like a player in the players in the basketball team, or it could be like in the case of a university that has payments that have to be made, maybe a deposit. You put a deposit in that you're going to begin the university's program, and then you decide maybe things are too difficult at work, so you forfeit that deposit.
Thank you very much. Thanks.
Very good.
Yes, all is clear.
All is clear. So we have, let me see here. IP law aims to protect people's mental labor. Okay, you can see it kind of right here, mental labor. So that is the correct answer. And some people, about pretty good majority got that one correct. And then types of intellectual property law, copyrights, and you can see the little C up here, the little symbol for copyright. And copyrights protect any type of expressive art. So that's one thing that it protects, is expressive art, such as writings, music, motion pictures, architecture, other original intellectual and artistic expressions. And you can see I put another one here at the bottom of the paper, and it has a little more expressive writing with it. It says all rights reserved. So a copyright gives the owner exclusive rights to, exclusive meaning the sole right, the individual right to reproduce their own work. So as the owner, you have the right to reproduce your own work, publicly display it, perform it, or create derivatives of that work. Okay, so theories or ideas are not protected unless they are captured in a fixed medium. Theories or ideas are not protected unless they are captured in a fixed medium. And that medium means it has to be recorded, like on streaming video like we're on now, or in a book, or literature, or written work, a music composition. The act of creation produces a copyright. So you can see this helps define that theory or that idea right here. Theories and ideas are not protected. Once there's an act to create, then a copyright is produced. This means that even unpublished works are protected by copyright laws. You may have already produced the work, but have not published the work. The use of a copyright symbol in the date is common, but it is not required to show that you own the copyright. Again, this is in US law. So the use of a copyright symbol, like I showed you earlier, that little, actually I have it here up at the top, copyrights, little C, is common, but it is not required to show that you own the copyright. Owners of copyrights are also given economic rights to financially benefit from the creation of their work. The law prohibits other people from using economic gains unless they have been given permission from the copyright owner. And C, there are a few exceptions to copyright exclusivity in cases of fair use, such as for a book review. So there are a few exceptions to copyright exclusivity. If you are giving a book review, for example, it's considered fair use. And current law protects works whether or not a copyright notice is attached or if it has been registered. Current law protects works whether or not a copyright notice is attached or has been registered. And in the federal agency charged with enforcing this act in America is the Copyright Office of the Library of Congress. And some of you may do some work in that area and are very familiar with the Library of Congress and how to copyright your work, whatever kind of works we just went over. Most copyrights are valid for the creator's lifetime plus 70 years. Okay, so we have another question for you. Copyrights protect which type of expressive art? Which type of expressive art?
Okay, that is a very interesting one.
So it can be challenging.
Yes, actually, I'm thinking about it myself also. Oh, we can have several options.
Yes,
there.
yes, you can choose all that apply. Choose all that apply.
Mm-hmm. I'm afraid that it was mine, business operation. So, because I think maybe some of the business operation patents can be also through some expressive art. I don't know, maybe throwing something at the wall, and maybe it is expressing art and you create some, I don't know, commercial activity or something like this.
We're going to go over those in just a minute.
Yes, it's very interesting.
Yeah. It makes you think, which ones?
And what is art?
Yeah.
And whether a concept can be considered an art.
There you go.
Or art, not an, but just art.
So we actually went over what the answer is on this, and you probably as the participants have gone through, we'll start talking about this. Are motion pictures an art, expressive art? Yes. How about writings? Yes. Architecture. That was one that was listed. I provided that. You know, architecture can be very expressive. You look at the various buildings that are around Moscow or any very, very large city in the world, Beijing, New York City, very expressive. How about concepts? What was the standard? Okay, think for a moment, what was the standard of theories and ideas? What had to be done in order to make them available to be covered under this copyright law? You had to produce something, right? So if the concept and idea is not, or theory is not actually produced, even if it's unpublished, it cannot be covered under copyright law. And the same thing with a business operation, it doesn't fit into expressive art. Okay, so the two that do not belong are the concepts and business operations. And I know there will be a lot of discussion, which is good, because maybe it's different under your form of law, so under your system. But that'll be good,
Yeah.
a good one for discussion.
Yes, so if anyone has got anything to comment on the concepts and business operations, can you please write it? So, and while the class will be very interesting to get your feedback on that.
And I would like to know, because I can think of some cases myself where I might think, well, maybe not. Maybe the case might be that it can be covered, but if you're giving that argument, then you need to give the reasons for the argument. You're making an assertion, and what is the reasons behind, let's say, business operations? It should be covered because, and what are the reasons for it being covered? Okay, so I think that was a good question for you. Another one here: a copyright excludes the owner creating derivatives. Is that true from creating derivatives? Or is it false? It depends. You don't know. What is a derivative?
Yes, by the way, what is a derivative?
I thought that might come up. Yeah, a derivative is an alteration of, or an extension, I should say an extension of the original product. So some way people think of derivatives is in the financial market. It's a good way to kind of give a similarity. So a derivative in the financial market would be a piece of paper, like an options contract. You have an option to buy something. You're not actually buying the product. You're buying the authority to buy the contract, or to buy the product. Okay, so it's an extension of the original product, and it just gives it ownership, maybe a lease or a license. Okay, that's where that comes in. So if you have a product, like if it's a software that's been copyright protected, and you want to sell a license for that product, the license itself may be the derivative. Does that make sense? Okay.
Yes,
so
absolutely correct.
Derivative is just another extension. It's a byproduct. It represents the product, but it's not the product itself. So options trading in finance is a good way to also think of it.
Yes, thank you very much. It's clear. So byproduct is the best, probably. Yeah. So, and
you can choose. Actually, there's one correct answer. Although some of these others, if you don't know what a derivative is, might be also another correct answer. So we're okay there. Don't know, and that's great. I like to see that, because then you can look up these. There's about 11% that maybe didn't know the answer or didn't know what a derivative is. And a copyright excludes the owner from creating derivatives. So the word excludes is the key here. So we could replace the word exclude with prevents or does not allow. Okay.
Mhm.
So the copyright does allow creating derivatives. So this would be a true statement. Okay, let me see how.
So it means that out of our audience,
Oh, I'm
only
sorry.
six
False. I'm sorry.
False.
I read it.
Oh, I was
That's
thinking
false.
that we're that bad. No, we are not that bad. So it's almost half.
The word I should have is false. Okay. So copyright excludes the owner from creating derivatives. That's false. You are allowed to license your product. You are allowed to use it in other ways that are extended beyond the product itself in maybe a written contract. Okay, very good. So types of intellectual property, we're going to talk about patents now. And I think there's probably a lot of people who have interest in patents. So a patent or patents protect the owner's invention from being made, sold, or used by anyone else for a certain amount of time. And patents give inventors the right to sell their product or to make a profit from it by transferring that right to another person or business. And patents also, depending on the type of patent that you apply for, your rights are valid for up to 20 years. Okay, for a patent. Be aware that patent protection will be denied if your invention is deemed to be obvious in design. There's these three characteristics: not useful or morally offensive. And again, this is in America. And then how do we define morally offensive? That would be something that you would have to prove in court if you were being sued for that or suing someone else. In order to qualify for utility, patent protection, an idea must be, it must be novel, non-obvious, and again, useful. So most copyrights are valid for the creator's lifetime plus how many years? Another question for you. Most copyrights are valid for the creator's lifetime plus how many years?
And while there is a voting, I have a question over to you. The questions arose while or during the previous questions. First of all, can a description of a concept be protected by copyright? Lisa is asking. Can a description of a concept be protected by copyright?
That's one of those it depends type questions, because if you simply write a summary, a very brief summary, it may be rejected. Mm-hmm. Okay, and I have seen that happen to where the Copyright Office will not allow it to be accepted unless it's a genuine and useful work. You know, that was part of it.
Thank you very much. And there's another question. So can a copyright style be covered by copyright law? So corporate style, is it subject to copyright law?
We're going to get into patents and how it applies to maybe those kinds of concepts with protected, where a company will have some type of protected invention or protected rights in that regard. You would have to argue that. And as I said before, I could think of a few myself where, you know, a business operation, for example, you would want to argue that that business operation somehow is artistic in some way. It's an artistic work. So it might be that you could argue under that avenue.
Thank you very much.
Sure. Most copyrights are valid for the creator's lifetime plus. Boy, we have a lot of different answers here, and that's okay. That's good. 5 years, 75 years, 50 years, 20 years, and 70 years. So some of you have probably remember me putting the last slide here, or last few slides. It says, depending on the type of patent. Well, what I'm asking in the question is copyright. So I might have tricked you. Okay. So I wasn't looking for the patent years. I was looking for the intellectual property or copyright. Our copyrights are valid for the creator's life of 70 years. So the majority, 80% of you got this correct. Fantastic. Okay, so we're making progress. And then patents must be novel. Okay, patents, we're going back to patents again. Novel means that the idea is different from all other previous ideas, referred to as a prior art. So it has to be different. Otherwise, if it's too close to the existing patent, they will not allow you to infringe on somebody else's work. If you released any information about your idea more than 12 months before you file a patent application, your own information about the invention would qualify as prior art and would eliminate your chance to file the patent protection. And this is very important because if you have a work that is of significance, it has a meaning, a very powerful meaning, financially or otherwise, you don't want to release it to the public, because then the patent office might perform a search and find that the work was released even by you, the original author, without a patent, and find that your application would need to be denied. And the patents must be non-obvious. So what does this mean, right? Non-obvious. Non-obvious means that someone skilled in the industry in which your idea will be used would not immediately produce the same idea. So it can't be something very simple everyone would think of. Again, that would be up to the patent office to determine how obvious it would be. Okay, so depending on, and there's an infinite number of possibilities in regards to what people might try to patent. So it would be something that would have to be interesting. It must be surprising and unexpected, even to those working in the industry, or in order to qualify under the non-obvious requirement. A little better definition. And for many inventors, this requirement is the most difficult and subjective of the three. So obvious, it is very, that part is obvious. And for the three requirements which we had for our patent types. Okay, so what is the proper procedure when an editor receives two or more manuscripts by collaborating authors based on the same data with conflicting result? What is the proper procedure when an editor receives two or more transcripts by collaborating authors? They're working together based on the same data with conflicting results. So publish both, or publish both manuscripts with, let me get to where I could see this. Even for myself, it's difficult to see. There we go. We can see a little better. Publish both manuscripts. Do not refer to the conflicting data. Publish both manuscripts with an editorial indicating which paper is more accurate. Decline to consider both manuscripts until the dispute has been resolved by the collaborators. Publish the paper of higher quality. Which would you do? And that's very common as well, to where you're going to publish something, put it into the public record, and that way there will be a copyright. But what if you have collaborators with different results? Each one is going to claim ownership, assuming that they would, and the results are different based on the same data. Give you a
Very
moment.
difficult questions. Well,
yes,
for some people to answer who are not specializing in IP law.
And it's a very real question, very applicable.
Yes, and I just wanted to say that we're very happy that Intellectual Property Development Foundation joined us as a partner also. And I know that the members of this foundation are watching us right now, the non-commercial
Very good.
organization. And
Welcome.
they are commenting also on something in our YouTube channel, which is, we're very grateful for this. Difficult questions, honestly. So, and very high topic questions, I would say, because this is what's going on right now all over the world. People are publishing so much and everywhere. And with internet development, it's so widespread.
Yeah, the amount of data collected is enormous, and the cloud computing, data analytics, IoT, all of these ideas have really added to the opportunity for the collection of a great deal of information. So I heard some statistics, and don't hold me to this, but I heard some statistics that within the last maybe 3 to 5 years, more data has been collected than all the time before that in human history. It's astounding. Okay, so it looks like we have a clear winner here in the red, and that is the correct answer. So the correct answer would be to decline, to consider the manuscripts until until the dispute has been resolved by the collaborators. So they may decide one was correct and the other is not. They may resubmit together and have maybe a combination of going over the statistics and the data and finding out where the errors are and making the corrections. Okay, very good. So intellectual property right law again, patent types. We're going to talk about the types of patents. We have 3 different types of patents that you can get in the US: a utility patent, and utility patents protect inventions that have a specific function. This covers things like chemicals, machines, and technology. Design patents. These types of patents protect the way an object or product appears once it has been made. Literally, its design. Okay. And these types of patents include industrial designs, something you might see from Elon Musk, although he has some ideas about intellectual property, about sharing, that are interesting. And plant patents, which I'm not sure if you have that in your legal system or not, but plant patents protect plant types that are asexually produced. This includes hybrids. So I'm going to go into each one of those a little bit more, so it'll give you a little more information if you're wondering. A utility patent, again, protects and covers things like chemicals, machines, and technology that have a specific function. And a utility patent is the most common type of patent. In the United States Patent and Trademark Office, the USPTO, gives patents for machines and devices, manufacturing processes in business systems, compositions of matter or chemical compounds, or improvements on earlier patents. So you can submit an improvement that are new, functional, and again, the word non-obvious. Design patents, which was number 2. These patent types of patents protect the way an object or product appears once it has been made, and then literally its design. These type of patents include industrial designs. So let's have another question here, and I'm going to throw you for a question that is maybe not related, but to the slide I just showed you, but is related to the topic. A scientist develops data while working at Harvard University. He then moves to Stanford University, where he publishes an article using the original. Okay, so who owns the copyright?
And Daniel, can I please ask you, or maybe it's too early
Sure.
to ask for does it mean? What does it mean? GAMA?
Oh, GAMA,
Yes.
the Journal of the American Medical Association.
Okay, because I was afraid that I may be jumping ahead of a train, but
In America, people in academia would most likely know that, but that's a great question. What is JAMA? So it's the Journal of American Medical Association. So this would be the journal that maybe it was published in. So the question is, who owns this? Harvard University, Stanford University, the scientist, or the journal?
So we have definitely here a competition, which is
The
great.
competition. It looks like we have a few more voting. And it's an interesting topic because many universities are looking at this saying, you know, do we have a valid possibility of creating revenue from the patents we might create in our university? So the university might be very interested in anything, a byproduct of research, because they pay for the research. And if they're paying you as a researcher, you know, who should get the copyright for that or the patent for
Yes.
for something?
And it is, in most situations, it's even expected, and in a lot of projects.
What is it like in Russia? Who would own this?
That is such a good question. So let us ask our audience, and who can you please phrase the question, and then we'll give the time for our audience to answer either in YouTube or in Telegram.
Okay. Given the same situation, a scientist develops data while working at, and you could name a
St. Petersburg State University. We're in St. Petersburg at the moment.
And he then moves to another university where he publishes an article using the original data and the original work. So who owns it is the question. Who owns the intellectual property on that? So
can I specify one thing? Speak about this question. Can we very easily track the chain of causation? Or not the chain of causation, the sequence, that maybe the move was very fast. So it's obvious that the data was developed while working at St. Petersburg State University as the original. Okay, so then we will really ask our audience to answer this question. I think they need to think over.
I think it's changing a little here. Well, we'll see what they say in Russia. But I can tell you in the United States, the word that stands out here is working. So if you are working for an organization and you develop the data there, then it is data that belongs to Harvard University. Okay, unless there's an agreement that is written that specifies that as the scientist, that it becomes your property, or that you can transfer that property to another entity. So without an agreement in advance, if you develop it working at Harvard, that's who owns the property.
Okay, and we have got some comments also in our chat. I would like to read them out. So, for example, Andrei writes that it depends on contract between JAMA and scientist, for example, in some situations. Then in our country, a scientist probably owns. Then it was Julia said, Valeria says, the employer has the right to the result of the employee if he, on the instructions of the employer, created, for example, the derivative or subproduct.
Okay.
So, and Yes, and also they say that Alexander says, I think that they use knowledge and have an employment contract. So what they invented is the property of Harvard. So
Very
that's
good.
exactly what you said.
Because if you remember when we started, we were talking about labor. And when you are an employee and you work, you're selling your labor. And there could be physical labor where you're actually doing something to physically move something or change something. Or it could be mental labor, if you recall that question.
Yes. And also we have over here our specialists, who are specialists, I know, experts in IP law. They say in Russia, it really depends on the employment agreement. If this result was the direct employee's responsibility, then the work result belongs to the employer. But there are some issues as usual.
Mm-hmm. And that can happen. And it does happen. I know I'm an alumni. I graduated from USC, the University of Southern California as well, and from many different universities. But at USC, University of Southern California, they attract new professors that have amazing ideas, new creations and inventions. And those professors generally, or the scientists that work in the labs, will generally get an employment agreement with the university specifying that the intellectual property belongs to them. There may be an agreement to share the patent property rights. Okay, so there's the various forms that you can take.
Yeah, just wanted to have a small comment also. I used to work for a university, and I have some colleagues, and the university was really eager for us teachers to contribute to creation of online courses. And I know that and we were sent to different courses to learn how to create online courses. And a lot of, I know teachers, they were against this. They were saying that if we do it, we contribute a lot of work, then the result will be the owner, the property of the university, and then we will be kicked out from job. And that is a big issue. Yes, that was absolutely just what my colleagues were saying. So, and that's very interesting question. And some were even leaving the universities because they didn't want to do it. So, well, that's the reality.
And these are very great questions because, or at least ideas to consider in the real world, how all of what we do applies so importantly. And when you're talking about employees and intellectual property, you want to encourage them, as I stated earlier, you want to encourage that innovation and idea generation so that the company or the entity that is employing them can move forward. And without the proper type of encouragement, people will not contribute.
Yes, absolutely correct.
What could happen is a good, very brilliant employee, if not given access to ownership, may leave the company and create a competitor. And that happens a great deal. So it's a great thing to address with your clients about intellectual property and how there may need to be a sharing agreement with the property rights that are created during employment, so that there's an encouragement to both contribute and be innovative, because the employee isn't what we call in America, not an entrepreneur. An entrepreneur is outside the company on their own. An intrapreneur, which is somebody who's within the company. So it's intrapreneur. And the intrapreneur has access to all of the financial resources, the laboratory equipment, if it's a laboratory, they have access to all the resources of the company. So it's a big benefit to the scientist to work for a company that can fund their research. And then if they could also keep a part of the royalties, for example.
Oh, yeah. So, well, yes, it's a very, very, very hot issue right now, especially because everything is changing so fast. Because when people were hired like 10 years ago, there was no such a question of creating online courses. Or, for example, we're speaking about the educational thing.
Right.
And so,
well, it's very similar to what I'm doing right now.
Mm-hmm.
So the intellectual property right of what I'm creating right now,
Yes.
In essence, I work for the American government in creating this content, and it's something I really enjoy. I don't simply do it for the money. And most teachers realize that you're not working for the money. So I enjoy what I do immensely, and I think it helps contribute to the rule of law, and it contributes to understanding and relationships and many other things that I do it for. But you had a good point with professors or teachers that are creating content for online courses. Once it's created, it belongs to the institution, and then the institution doesn't necessarily have to have the same teacher teach the class again.
Yes.
They can use those resources and provide them to another new teacher or another professor, for example. Yeah.
And that is, and as we have even comments, as we have some teachers also who are watching us right now, that one of them saying that at my previous university, we were asked even to develop such courses for free as an additional work. That's another even situation, which is totally understandable. Okay, I will leave now the floor and we can go to the patents. Yes, thank you very much.
Just one last comment on that is that I would, if in that position for those teachers that are out there creating content, there is value for that content. So something that could be negotiated, maybe. So that's just a thought. Okay, so we'll go back to our ideas here. I'm going to, there we go, without moving it on you. Types of intellectual property law. Again, we have patent or plant patents, and plant patents protect plant types that are asexually produced. These include, hybrids. And what is a plant patent? What is that? Well, these are plants that reproduce by means of other than from seeds, such as by rooting of cuttings. So if you cut a plant and you put it into the ground and it grows new roots, layering, budding, grafting, or enarching. Okay, so there's different ways of producing plants other than normal sexual production. In an asexual production, we have it being, and I'm sure that there's grafting and layering, budding, buds on a plant. Do you know what those are? Grafting is when you chop a plant and attach that to another. Enarching is to put it into another plant as well. So not all countries allow the patenting of plants, but the USPTO issues a patent to anyone who has invented, discovered, or asexually produced a distinctly new plant or kind of plant. So you could have a plant that you have pollinated and have created, and this happened with tulips back in the 1600s. They had a very big tulip boom. And that was created by plants that were unique. So plant patents, some more on this is what is a plant patent? This includes any cultigen, mutant species, hybrid species, and newly found seedlings not derived, there's that word again, from a tubular produced plant or a plant found in a wild state. Okay, and plants cultivated using tubers and wild are uncultivated plants and not patentable. So it has to be something where there's been some type of alteration that has been made. Remember that it can't be. It has to be unobvious or non-obvious. The term tuber means short, thickened underground stem or rhizome. Plants covered by the term tuber propagated include the Irish potato. So there's an example for you. Jerusalem artichoke, yams, and peanuts. Again, on patents, investors do not automatically get a patent once they invent something new. So they don't automatically get it just by the process of inventing. They must apply for and receive approval on their patent to be protected under intellectual property law If you have never applied for the patent before, it is recommended that you hire a patent attorney to assist you through the complex and time-consuming process of applying for one. And usually, if you have not, and you have the ability to understand well, you can apply for a patent through the U.S. Patent Office through the use of a patent attorney. Might cost you more the first time, and then after the first time, you'll probably be able to do it on your own. So which of the following is not protected by trademarks? We haven't talked about that before. We're going to, but I want to see what you know up front. Which of the following is not protected by trademark laws? Logos, book titles, pseudonyms, trade dress.
Okay, so Daniel, am I too fast to ask whether a trade dress is a fictional word or expression, or it's a legal term? Because I've never heard of it, but I'm not honestly a specialist.
Trade dress?
Yes.
Yeah, it's a way of creating a something that appears similar to a logo, but a dress itself. It is something that you put in front of your product, and it's something that's recognizable.
So it's not literally clothes. Yes, like, I don't know, a skirt or a dress. So it's not like literally a dress. So
it could be trade dress as well, to where, for example, you may have Mickey Mouse for Disneyland. Okay, which is recognizable, or Ronald McDonald for McDonald's hamburgers.
Well, yeah, because they are always very specific costumes. So
right, and that would be something that might be able to be trademarked. It has to be specific, and it has to be something. We'll go into what trademarks mean. I was just trying to get an idea from the audience right now, from the participants, what they thought up front. But very good questions. We're going to go over these in just a moment.
And then, can I please then, while we are waiting for the voting, I have a question, which is a little bit about derivative. Everyone loved the word derivative.
I like it.
Is a caricature depicting some image or superhero can be protected by IP law as derivative? Because magazines, mass media have lots of them. When you know there is a mock picture of a superhero, and can they be sued for infringement of copyright if they make a caricature of some superhero, for example?
You know, that would be debatable on how authentic or accurate it was, you know, compared to the original. And in those kinds of suits are argued all the time, you know, that somebody has infringed on a caricature that an artist has created. An example might be, do you know the Snoopy?
Yes.
Yeah.
Snoopy
So Snoopy dog. So it's a very simple drawing, but if you were to take something and imply that this was something where Snoopy was endorsing a product, for example, you could be sued because you're manipulating that representation, that characterization, in order to gain financially from it. So the owner of the copyright would then probably take action. So I would assume that's kind of what happens with derivatives many times is you may own a contract for the creation of an NFT, for example, non-fungible token, which is next week or next session. But if we're looking at IT, intellectual or information technology, or other products that are not created yet, but you own a contract on it, that would be a derivative. So you can own a derivative on an artwork piece that has not been commissioned or created.
Thank you very much. That was a question from Dmitry Kizyanov. So thank you.
Problem. So the correct answer on this was for book titles. Okay, it's not protected on a book title. It's not extensive enough, and it's too simple. Okay, and we'll go into those in a moment. But the others are protected. Logos, pseudonyms, and trade dress are protected. So what are they? What are trademarks? To help protect the names, marks, slogans of products and companies. Trademarks make it easy for customers to distinguish competitors from one another. That's one thing. Anything that would be very similar to your trademarked representation, as I said earlier, you might alter a competitor's mark or what would appear to be a benchmark, a great idea, alter it slightly, but not enough to where it would infringe on the trademark of another. So it also helps to avoid any confusion, and it deters misleading advertising. As I said earlier, you could have a representation of a very famous caricature endorsing a product, and that's one thing you don't want, is misleading advertising. So trademarks are automatically assumed, and that's an interesting take, because in patents, we had to get the patent office to issue our patent and approve it. In this case, with trademarks, they're automatically assumed. So as soon as a business starts using a mark or brand name, you can follow up that symbol with TM without having to file it with the government. So that TM stands for trademark, and you would put that after your item that you want to be marked as your property. So unlike copyrighted works, trademarks receive different degrees of protection depending on these issues: consumer awareness of the trademark, the type of service and product it identifies, and the geographic area where the trademark is used. Okay, so rights can be potentially lost forever, and while not required, trademark owners can register their trademarks for additional protection. And generally, the way that this is done is you can have a trademark on a product, and you may have had it for many years. And if somebody starts to advertise using your trademarked logo, for example, you would need to take action, probably write them a formal letter from your attorney, or have you as an attorney would write it and notify the person that's infringing that they are infringing upon your rights of that trademark, and ask them to cease or face action. And then if you don't take action over a period of time, the trademark will assume to be in the public domain, if you remember that term earlier. And if it gets into the public domain without you trying to protect your property, the owner trying to protect their trademark, then it will become public domain and then no longer be protected. So there is no international copyright law. Is this true or false? True or false?
And actually, Daniel, for the first time, we have some people who disagree with the correctness of the answer. And I would like to voice it, because I like it, because lawyers always disagree. So
I know.
Finally, they do it even in comments. So, and we have one lawyer who says that he considers that book titles could be specific, as some non-existing word could be used. So in this situation, probably the book title may be kind of protected, like and it can be considered the trademark or something like this, or
it's one of those things of it depends, and it depends on many things. And if you remember the words in there, there's some a level or degree from low to high as to the importance of the words that are being used and the uniqueness of which they're used. So if it's a very common word in a title, if you said, let's say the title of your book is Bible, that would be very difficult to get through the patent office or copyright office in order to get it known as your property, because it's too much out in the common, out in the domain, the public domain. So there's where the problem
very
is.
specific. Yeah, but if
Yeah,
it's very
if it identifies probably a previously documented work or documented artistic work, you may be able to tie it to that, but that would be something you would need to argue. If someone infringed upon your rights that you felt, then you would need to argue that that was unique enough, that it wasn't used in the public domain and it was a very new word for it, or the symbol of infinity that's being used by Facebook now. That would be very difficult to argue, I think, unless there was something really unique about the symbol.
Mm-hmm.
So
Okay.
it makes me wonder how they plan to ensure that no one else uses that symbol.
Well, it's the job of the lawyers.
Yeah, and that would be a difficult one to argue, that symbol itself is the name of their company, therefore no one else can use it.
Yes. So as always, it depends, but in generally book titles are not.
In general, they're not. And I've actually attempted to patent one myself and had it declined. So I can tell you from personal experience that, yeah, it really depends on how unique, and if there's previous work that is established that ownership belongs to you.
Okay, thank you very
Otherwise, they would have, you could imagine the number of patents that people would have on every conceivable word if they could patent a word and then derive premiums for the use of a word, for example. That would be difficult.
Thank you.
Okay, so there is no international copyright law, and that is true. There is no international copyright law. There are treaties. So you may be thinking of WIPO, for example. And again, you may have a dispute on this answer as well. And maybe people are looking at it a little differently, thinking I'm saying there is, but no, there is no international copyright law. There are agreements and treaties and conventions. So types of intellectual property law, which are graphical indications. Graphical indications are signs or images used on products that come from a specific geographic location. Often people do this when that location has certain qualities, a reputation, or characteristics that make the place of origin special. So it is important to note that copyrights, patents, and trademarks are the basis of on which intellectual property is protected by law. Therefore, it is important that a certain degree of skill is used when drafting the documents required to obtain these protections. If you do not have this degree of skill, you should hire an intellectual property lawyer who has specific experience in your field or industry. Good advice for your client. So which of the following is true regarding data sharing? Which of the following is true in regards to data sharing? Let me see if I can make this larger. Here we go. Authors should not be required to provide access to data during the peer review process. Once the results from analysis of data have been published, the original data no longer need to be made available. Journals should lessen their emphasis on the reports of the secondary analysis, or data sharing should be a regular practice. Now, you may find that sometimes journal articles are written and there's that conflict. Who owns the data, and should we share the data? That's the question. And then who becomes owner of that data?
Yeah, I can say from my personal experience, if I again jump in,
Please.
that was very interesting situation when I was preparing for defense of my thesis for my PhD degree. I was told that it was in a different university I was defending it, that they have a tradition that you upload your unpublished work on a public computer in the department, so everyone can go and revise it before the defense. And it wasn't even published, it was like pre-defense. And I remember that my scientific mentor, if I may say so, from another university, she was horrified because she said, but your work is unpublished yet. Someone can copy it and go and defend it in another city. And it was just a new procedure that was established, and we were debating on it so much, because I remember I was very much afraid to upload it. So that when the procedure is not regulated, it really creates ambiguity and horror and problems that may arise. Yeah. And I worked on this for 3 years, so, and I was really afraid. So
yeah, and especially a PhD, that's your baby, and you take good care of it, and it's very important. And I'm sure a lot of time was spent on making sure that you analyze the data properly, use the proper statistical analysis, and just a lot of labor went into it. And to share
and it was different approach in different universities from different points of view, and it was like pre-defense before the official one is published. It was like training, and it was a tricky question. I still remember it's a problem for the creator.
And it's a problem because the exact reason we're discussing this topic today is, how do you protect that mental labor, right? How do you protect that labor? And if there's no protection for it, you will be less likely to contribute to academia. You're not going to give things willingly or easily, because other people might steal your idea.
Yes.
And that's and that, to be honest, that can be a big problem in academia, where people are looking for an idea. You come up with a very good, unique, solid idea, and others take it from you. So that's a very valid concern and a reason for us to have this discussion. And it looks like we have a lot of answers here. That's great. They vary almost equally. One's a little more, but not too much.
Yes.
And the proper answer is the one that has the most number of answers. At least that is the answer that is given by the Journal of the American Medical Association, that the data sharing should be on a regular basis, and data sharing in the context in which Sophia was speaking of, we covered earlier when we said even unpublished work is covered. Okay, so you would look at the date of her conference in which she provided the data. It wasn't published yet, maybe, and it may have been a dissertation defense or practice defense. It could be data that you put on a website to provide for people who are going to maybe provide feedback before your dissertation is published. So that is a very valid issue. The way that I look at it personally is, in many cases, there are some things, very few, but there are some cases which I want to protect and copyright ideas that I have. But in many cases, the ideas and the information that I put out to the public, like we're doing right now, I gather from others and build on their work, just as we do in academia. And to give credit where credit is due. And then also to acknowledge that, this probably isn't going to be my last idea. So the next time I provide information to someone, I'll use this experience in order to build on for myself. So, and I hope that's the way most people in academia at least look at it. You're a work in progress, so it will continue. So data sharing should be a regular process. And the reason it should be that way is like I said, we build on each other's work. If there is an awesome idea, something that's very innovative and unique, then you provide that to the scholarly community, to the academic community, and better ideas are built on that. Right of publicity. The image and name of a person are protected by different state laws known as the right of publicity. So in the United States, we have something called the right of publicity. The image and name of a person are protected by different state laws. So you can't just take somebody's picture and use it in order to gain in some way, financially or otherwise. These laws protect people against the unauthorized use of their name and image for commercial purposes. So you can imagine if you were to take a picture of somebody very famous and try to sell a product or endorse a product using that person's picture without their consent. The right of publicity again. For example, a company cannot use a picture of you on a cereal box unless you give the permission or are compensated for the use of it. The extent of your protection varies from state to state. Okay, in the United States, state laws have precedence. Trade secrets. This is one of them I think we touched on. A trade secret laws can be found at both state and federal levels. They protect sensitive business information like a marketing plan for the introduction of a new software or a secret recipe for a brand of soda. And you may see this in your country where you have some famous restaurant or a famous product that is sold, and there's a trade secret as to the menu or to the recipe. And the extent of its trade secret protection depends on whether or not the information gives your business an advantage over your competitors. That's another thing. It needs to have a benefit above your competitors. Kind of getting back to that non-obvious issue. It must also be a secret among most of your staff and not be known by any of your competitors. So you have to retain the secrecy. Right of privacy, and this may also be something that's different under your legal system. Although not technically part of intellectual property law, state privacy laws are there to protect the rights of all people to be left alone. So invasion of privacy happens when a person publishes or exploits someone else's private information on a public forum. Invasion of privacy laws protect people from intruding on, exposing information about, or falsely portraying another person. Intellectual property law infringement is when someone uses a person or a company's intellectual property without authorization. Article 1, Section 8 of the U.S. Constitution grants Congress express authority to give authors and inventors exclusive rights to all of their creations. So it's citation here. Section 8 also gives Congress the power to provide further support, both interstate and in foreign commerce. Okay, and Congress's power to regulate trademark is grounded in the common commercial clause of the Constitution. Some more citations. Intellectual property laws passed by Congress are overseen by two government agencies. I mentioned this before, but it's the U.S. Patent and Trademark Office and the U.S. Copyright Office. The U.S. Patent and Trademark Office is responsible for issuing and monitoring all federally registered patents and trademarks, while copyrights must be registered with the U.S. Copyright Office to be enforceable at the federal level. To protect yourself against infringement, you should take all of the steps you can to let the world know that your rights exist. So very important. By making your rights public, you deter people from who might accidentally infringe on your rights, and you put yourself in a better position to prosecute an infringement in your court if necessary. How to give notice of your intellectual property rights. So inventors can give notice of their rights in the following ways. They can mark their product with the patent number that is assigned to them by the Patent and Trademark Office. They might have something like here, patent pending. If you do not receive or have not received their patent yet, then you can use the label patent pending. to discourage people from copying the design before they receive the actual patent. A notice of trademarks and copyrights can be shown by placing the appropriate symbol, such as the TM trademark or the copyright symbol on the products or materials. So which of the following is not protected by a copyright? Try this again. Which of the following is not protected?
And while we're waiting
Sure.
for the answers, we have again the questions. So the question is again about copyright from Delia. Is street art protected by copyright in the US? In your opinion, street art?
Yeah, what I should do on that while their voting is going on is, let me go back up here and show you something here. See if I can find it for you.
I'm honestly trying to answer the question.
Yeah, it cannot be morally offensive. That's where I was going to, is this here. So depending on the type of the patent or copyright. So if it may be that it could be argued that it is morally offensive.
You speak about street art, yes?
Street art. So you would have to argue it's obvious in design, that if it might not have patent protection if it's not useful. You could try to argue that on street art, and it's morally offensive. So on owners of copyrights have been given economic rights financially. The law is prohibited from economic gains unless there's given permission from the copyright owner. And for use in the question here, there are a few exceptions to copyright exclusivity in cases of fair use, such as to extend the thought that you have on this topic, on this issue, the question you're asking me. How would if it were a protected right, how would the owner of that protected right use that? Is it of use?
Yeah.
And
Okay.
I would tend to argue that if it's street art, it would probably fall under it probably immoral, but it could be illegal because it's been put on something that is public, like belongs to a government entity, municipality, state, federal government, or a private citizen whose property has been defamed or damaged by the street art. And then if it's useful, and it may not be useful because it may be that art can be, because if you're putting it onto the side of somebody else's property, that the property owner, street art, whether it's a government entity, municipality, or an individual, that the owner of the property probably would have the right to discard the property that it's attached to, or to repaint over. That would be my question: is what do they want? What do they want in terms of they might have a derivative from the street art, which would then be a photograph or a picture of the street art that they might claim as a right to the derivative.
Okay, thank you very much. We have a couple of more questions, but I think I will leave them for the for the end.
So on this one here, what we were looking at, and I put an explanation here, a copyrightable work.
Yes, and can we ask you to do it a little bit smaller, just a little bit? I mean, the big one, if it's possible.
There we go.
Yeah, thank you.
It cuts off a little bit. but it's because of the technology. So a copyrightable work must be fixed in a tangible medium, okay, of expression, and includes the following: literary works, musical works, dramatic works, pantomimes and choreographic works, pictorial graphic and sculptural works, motion pictures and other audiovisual works, sound recordings, and architectural works. The following are not protected by copyright, although they may be covered by patent and trademark laws. So the question was about copyrights. So it might be a little tricky, okay? So if it's protected, the following might be protected by patent and trademark laws: works that are not fixed to tangible forms of expression, like speeches, performances that have not been written or recorded. Titles, names, short phrases, slogans, familiar symbols or designs, mere variation of topographic ornamentation, lettering, or coloring, mere listings of ingredients or content, ideas, procedures, methods, systems, process, concepts, principles, discoveries, and devices as distinguished from a description, explanation, or illustration, and works not consisting entirely of information that is common property and containing no original authorship. So those are excluded. They're not protected, although they may be covered under one of the other forms of IP. Now it kind of alludes to a question you had earlier that I spoke of. You know, and this is the tricky part. That is the part in terms of arguable, how you're going to sustain the right, if it is truly a right that you are allowed. If infringement does happen, you can enforce your intellectual property rights in federal court in the United States. Before filing a lawsuit, you should consult with an intellectual property attorney if you are not already one, and carefully consider whether litigation is your best option. Usually the better option is not, because of this issue here in the third case. Infringement cases are expensive, and there is a risk that your intellectual property rights, once held up to the scrutiny of a judge, will be shown to be invalid or less extensive than you may have thought. So if you feel that you have rights and you go to litigation, or you go to litigation with your client and the client loses, then they lose those rights as well. So there's some risk involved. If you decide to go to court over an intellectual property infringement and your suit is successful, there are a number of remedies available to you. The court can order an injunction asking them not to use it. This means that the person infringing upon your IP must stop what they're doing. You may be able to receive monetary damages if you can prove that you've lost business because of their actions. And actions to take continued. Once your rights are established in court, you may have the ability to argue a license or agree to a license agreement with your IP, which is great. So that would be one way of doing it, is licensing with somebody who's either accidentally or intentionally infringed on your rights and has been caught doing so through mediation arbitration. This means that the infringing party can continue to use your IP and you will receive a payment from them in return. So intellectual property protection at an international level, we touched on this just slightly, is an important issue during trade and tariff negotiations in the 19th century. On the first international treaties relating to intellectual property was the International Convention for the Protection of Industrial Property, also known as the Paris Convention. And most attorneys know about this. And I put in here a slide just showing some milestones where I know we're almost near the end of our time. I have one last quiz here for you. Which are milestone treaties? Do you know these, you attorneys out there? Okay, so select all that are.
And that's a very good question, because right now, even in chat, we have some heated discussion about import of goods bypassing sanctions. Some importers selling trade marked goods abroad. So which law applies in the place of infringement, and so on and so forth. And we have some comments which are going on, and Paris Convention is mentioned and others.
Yeah.
So it's quite interesting. So
Yeah. And anybody that's done the Vismoot would know a lot of these. Do you have the Vismoot there at your university?
Yes, actually, and a couple of years ago, I don't remember, was it 2 or 3 years ago, we even had a team that won Vismoot. So
fantastic.
if I'm not mistaken, I don't remember, I think it was the High School of Economics, and we're extremely proud of them because it was a great achievement that they won. So if I'm not mistaken, yes. So we do participate. So, and it's a big thing in Russia.
Well, I don't want to run over too much. We're already a minute over now, but it looks like the New York convention is 0, and that's great because that one is not listed there. And it's incorrectly spelled as well in convention. So the world provider of global IP services is the UN, and some of the things that you can do: patent cooperation treaties, like patents, trademarks, industrial designs, graphical indicators or indications, and then WIPO, which I just mentioned. And there's some information here at the end of the PowerPoint about international protections and the WPO or the WIPO, which is the World Intellectual Property Organization through the UN here. So if you get a copy of the PowerPoint, this will be in it. And there's also a video here that I put in there so that you can take a look at that through the link. Okay.
Thank you very much.
And that's it for today. Thank you. We almost made it.
Thank you very much. Yes, and thank you very much. It was extremely interesting, and we could see that there are a lot of disputes. It's very questionable area of law. It's very high topic right now, and we are very grateful to you for providing us the insight into the vocabulary, because it's all listed here. So, and as we will upload it to the website, it can be used. So your work, which is copyrighted, will be in the public domain.
There you
officially.
go.
Yes. So, and thank you very much. Thank you.
Okay. Well, thank you, Sophia. And thank you for all the participants out there. I hope to see you next time. We have the FinTech.
Final. Yes. So in 2 weeks, we're actually going to have our final webinar, which is going to be dedicated to probably even the hottest topic of the modern types, which is FinTech vocabulary. So, and everyone is very eager because it's totally unknown area for many people, and very interesting. So we are looking forward to it. Thank you very much. Thank you, and see you in 2 weeks for the final webinar. So we are very welcome. We're welcoming everyone to join, and after that, a test is looming, and everyone is eager to take it. Okay, fantastic. Thank you so much. Thank you so much, and have a great day.
Okay, bye-bye.
Bye-bye.